All right, well, let's talk about the supposed fight for women's rights over here in the States. It's bizarre. We're very, very focused on abortion as a country. I mean, it's been probably the most consequential cultural issue that we've been dealing with for the past 50 years since Roe v. Wade in 73. And it's had massive positive effects on the conservative movement in a way, you know, in galvanizing them and so on. Though obviously conservatives would say massive negative effects on the country's morality, on the well-being, obviously, of our future generations and so on. We get this law out of Texas, the Texas Heartbeat Act, which for those who haven't been paying attention, nearly all Republican lawmakers signed on to it as authors or sponsors, and only one Democrat sponsor, and it was signed into law by Governor Abbott, who has, we believe, presidential ambitions in 24. It makes Texas the most restrictive in the nation for access to abortion. It bans most abortions after about 6 weeks of pregnancy when you see a heartbeat, fetal heartbeat. No exception for rape or incest, permits later abortion if the mother's life is endangered, and it deputizes private citizens to sue anyone who performs or aids and abets an abortion, but cleverly bars state officials in Texas from actually enforcing the law. That's how they're avoiding federal jurisdiction over this. They're trying to ban the Supreme Court or to prevent the Supreme Court from getting involved, and so far they've been cleverly successful. The plaintiffs need to have a connection to the patient or the clinic if they want to sue, and you can sue. You incentivize these lawsuits against those performing or helping with an abortion at $10,000 in reward money. Okay, so this is just the latest, but again, the most clever and controversial attempt to get around Roe versus Wade, which will come up for review this term in the normal way, in the way where, you know, both parties are going to argue that it should be overturned, it was bad law, and so on. This is a different way to crack away at it. And the Supreme Court declined to hear the case. All of the reports I read, Alan, are basically, Supreme Court is basically backing the law. They're backing the law. They allow, well, I don't see it that way. I don't see them backing the law. In fact, they expressed skepticism about its constitutionality. So you tell me what the Supreme Court actually did, and then we'll get into what you think of the law.
The Supreme Court did not have the courage to do what it should have done. It shouldn't even have reached the abortion issue. This is the most dangerously unconstitutional process for challenging a law that I've seen in the 55 years I've practiced. Imagine if it was turned now next against gay marriage. So the state outlaws gay marriage. It's unconstitutional. But the state says anybody who wants to challenge a gay marriage just has to go to court and collect $10,000. What the state has done is deputized ordinary Budinskis who are money hungry to do the job for them. Or let's turn it on its side and say, let's say the progressives who don't care about the law and don't care about due process decide to turn this against the Second Amendment. So they could pass a law in New York or in California saying nobody has the right to have any guns. We know we're violating the Second Amendment. Nobody has any right to have any guns, but the state's not going to enforce it. Any anti-gun person can sue any store, any company that sells guns and can get $10,000 for that. The process is what's so dangerous. Imagine if that were used to stop desegregation in the South. It could be used to stop anything constitutional. And that's what was so disappointing about 5 justices of the Supreme Court not stepping in. And I think Justice Sotomayor got it exactly right when she focused on the process, not even getting to the abortion issue, just the process by which the state is trying to circumvent Marbury versus Madison, the Supreme Court, the Article 3 of the Constitution. It's just undercutting everything that the process of law stands for. And I hope that a wiser Supreme Court will ultimately strike down this statute and tell Texas and tell the rest of the states, you cannot circumvent the law and the Constitution in this way. You can call it clever. I call it devious.
There's no question that that's what they're trying to do. They're trying to circumvent Roe versus Wade. I mean, there's no question about that. But I would say, you know, the people who I've heard defending this, and to be honest, there haven't been that many. I mean, to be perfectly honest, even legal scholars who are from the Federalist Society, I've heard quietly saying, no,
even Donald Trump has not really done what one might have expected him to do. He's remained relatively quiet on this. Because it's indefensible. It's indefensible.
And just as a political matter, it's a slippery slope. As you point out, there are a lot of trusted, valued rights on the right half of the country, like gun rights, as you point out, that they don't want states like New York or California messing with. And the fact that gun rights are enshrined specifically in the Constitution may not be of much comfort to people if this is a precedent one can follow. What do you make of, I've heard some say, well, it's a little different with gun rights because unlike abortion and this so-called privacy right on which it's based, gun rights are specifically spelled out in the Constitution. You know, they're right there in the Second Amendment, whereas the privacy right from Griswold.
The Second Amendment.
Well, I'm just saying, but the Second Amendment talks about the right to bear arms.
Yeah. I agree with you.
Whereas privacy and abortion is judge-made law.
It is, but so is Heller. So is the decision to undo 200 years of precedent that said the Second Amendment doesn't convey a personal right to own guns. I'm not quarreling with that. But the Constitution is very rarely clear. It's clear. You can't run for president unless you're 35 years old. But the Second Amendment isn't so clear. And the right, many of our most fundamental rights derive from other amendments, the Fourth Amendment right to privacy. So I don't see the distinction between gun rights and abortion rights. Both are controversial. Brown versus Board of Education. There's nothing in the Constitution that says that separate but equal is not permissible. That's judge-made law. And
do you see Roe v. Wade as, what's your opinion on Roe v. Wade? Because I mean, I know a lot of even Democrat scholars who will say that's a BS opinion.
When it first came out, I said it was not necessarily justified by the text of the Constitution, that it would have been better for women. I'm a strong supporter of women's right to choose abortion if it had been left to state legislatures and we hadn't politicized the issue and turned it into something that strengthened the conservative movement. Remember, we're the only country in the Western world that is focused on abortion. Ireland has permitted it. Italy, the most Catholic countries in the world, now permit abortion. Only the United States, it still remains an issue. So whatever you think of Roe versus Wade, there were scholars also who criticized the rationale of Brown versus Board of Education. Herbert Wexler, the great constitutional scholar, many others did, but nobody would dream now of reversing a 1954 decision, and nobody should think about reversing a 1973 decision. Whatever you may think of it originally, Marbury versus Madison was very controversial at the time it was rendered. But precedent has its role in constitutional adjudication. Stand by what you have said.
Okay,
That's
so on that front, given that the court, and I will say I disagree with you that the court did the wrong thing in punting on this, because I do think it was a weird circumstance. They were being asked to enjoin something where enjoin a judge, basically, but no one had actually sued. If somebody had sued under the law and said, you owe me $10,000 for driving somebody to an abortion clinic, bingo, you're on. There's a judiciable whatever issue and justiciable, and they would have taken that case, I believe. It was just that they were like, there's no one here real who's been sued, and we don't really have a live case in front of us.